In the matter of JAMNALAL versus the state of Rajasthan, Supreme Court allowed the appeal and set aside High Court order of suspension of sentence. Respondent 2 had been found guilty for offence punishable under Section 342 of the Protection of Children from Sexual Offences Act 2012 for short POXO Act, as well as under 376(3) of Indian Penal Code 1860. Respondent 2 was sentenced under Section 342 of POXO Act and no sentence was imposed under Section 376(3) in view of Section 42 of POXO Act. Insofar as Section 342 of POXO Act was concerned, Respondent 2 was sentenced to undergo 20 years rigorous imprisonment and ordered to pay fine of 50,000 rupees. In default of fine payment, Respondent 2 was directed to undergo additional 2 years rigorous imprisonment. Respondent 2 had undergone imprisonment for a period of 1 year and 3 months, after which his sentence was suspended by High Court. High Court, while suspending sentence after setting out contention of respective parties, had recorded only following reasons before enlarging Respondent 2 on bail. On consideration of arguments advanced on behalf of appellant as well as learned state counsel and counsel for complainant, and having regard to facts and circumstances as available on record, and especially the fact that no sign of sexual assault was found by medical expert on body of prosecutrix, no FSL as well as DNA report is available on record. Despite availability of washrooms in house, it is little difficult to digest that prosecutrix will go out for toilet. There is no prospect of being heard and disposal of this appeal in near future. Court is of opinion that appellant has available to him strong grounds to assail impugned judgment of conviction and sentence. Thus, it is fit case for suspending sentences awarded to applicant during pendency of the appeal. Trial court, while convicting respondent 2, relied on evidence of prosecution witness 3, who had deposed to following effect. On 13 June 2023 at 4 p.m., when she had gone to field to defecate, respondent 2 came from behind and at gunpoint, after closing her mouth, took her to Ambrose's house near the dry tank located in field. Thereafter, prosecutrix deposed that respondent 2 committed rape on her, that she came back and narrated incident to her mother and other family members, that her father had gone out at that time and came little while thereafter, that she went with her father to police station where her father lodged FIR. She also deposed that she was medically examined and had given her undergarment and pajama to doctor. Statement under section 164 of CRPC 1973 was recorded earlier, where she maintained her case against respondent 2. She further deposed respondent had forcibly removed her clothes and laid her on mattress on cot on ground floor of house. Dealing with medical evidence, trial court stated prosecutrix was medically examined and evidence was to effect that no external visible injury was found on body and genitals of victim and her hymen was in old torn heel state. One would have expected High Court hearing application under Section 389 of CRPC for suspension of sentence to examine whether prima facie there was anything palpable on record to indicate if accused had fair chance of overturning conviction. In matter of Om Prakash Sani versus Jayashankar Chaudhary and another, court had following say on the scope of 389 section of CRPC. Principal underlying theory of criminal jurisprudence in our country is that an accused is presumed to be innocent till he is held guilty by court of competent jurisdiction. Once accused is held guilty, presumption of innocence gets erased. In the same manner, if accused is acquitted, then presumption of innocence gets further fortified. Taking into account the fact that High Court had not adverted to any of the relevant factors was considering the case for suspension under Section 389 and keeping in mind antecedents, Court said we are of opinion that High Court was not justified in suspending the sentence. Reasoning of High Court set out above falls far short of parameters in Section 389 of CRPC for enlargement of convict punished for heinous offence on bail after suspending sentence. The finding that no sexual assault was found without considering overall nature of evidence of case is completely untenable. According to evidence of prosecutrix, respondent 2 at gunpoint closed her mouth and forcibly took her to house of Amr and committed rape. All the medical evidence said that no conclusive opinion about crime could be given since FSL report was awaited. That does not mean that ocular evidence could be ignored. As far as non-availability of FSL report is concerned, prosecution explained situation and trial court found that non-availability of DNA report did not adversely affect case of prosecution, reasoning that despite availability of washrooms in house, it was difficult to believe that prosecutrix could go for toilet out and is conjectural in nature. In the case of Vijay Kumar versus Narendra and others, the court observed as follows. On perusal of record and on consideration of submissions made by learned counsel appearing for parties, we are of the view that in context of facts and circumstances of case, High Court was in error in passing order releasing the respondents on bail. High Court had neither given any reason nor has indicated any exceptional circumstances for granting bail to respondents. In above circumstances, it is difficult for us to even surmise the circumstance which prompted learned single judge to consider accused person to be entitled to discretionary relief on bail pending the appeal. Principle is well settled that in considering prayer for bail in a case involving serious offence like murder punishable under section 302 IPC, court should consider relevant factors like nature of acquisition made against accused, manner in which crime is alleged to have committed, and the gravity of offence and desirability of releasing accused on bail after they had been convicted for committing serious offence of murder. Though said in the context of Section 302 IPC, it applies with equal force to a case of present nature under the POXO Act also, said Supreme Court.